The Ripple versus the SEC case could come to an end soon, as both sides are slowly coming to the public with their greatest evidence. However, now 2 new memos have been leaked which could literally change everything. What did they say? And what impact will they have? Stay tuned till the end of the video to find out. But first, we are giving away 50 XRP coins at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comment section. Welcome back, XRP Army. Ripple's legal struggle with the Securities and Exchange Commission of the United States has lately seen new developments, which, according to some commentators, may herald the beginning of a final resolution of this extremely important problem. When Ripple must unseal a batch of 2012 files by February 17, the information contained in those documents is likely to have an impact on the attitudes of both the court and the broader public in favor of either party, depending on how they are interpreted. Despite the fact that there is yet another twist in the story, the court's decision to accept some of the SEC documents as discovery has the potential to set a precedent for similar litigation involving federal executive agencies in the United States in the future. The following is a glimpse of the current state of affairs ahead of the next round of the competition. In contrast to many other cryptocurrency companies, Ripple has chosen to go the distance and participate in a legal battle in order to safeguard its coin. Upon winning its case, the SEC will be able to point to judicial precedent to back its claim that it has effectively controlled a major sector of the Bitcoin market using tried and tested securities laws. As a result, if Ripple prevails, the need for a more comprehensive regulatory structure that can be tailored to diverse types of digital assets will become more evident than it has previously been. However, it goes without saying that the Securities and Exchange Commission's regulatory objectives would suffer a substantial blow if this were to happen. However, while both Ripple as a company and the raucous online community of its token supporters, known as the XRP Army, have had an acrimonious presence in the cryptocurrency field, it is expected that the outcome of the case will have implications for the entire digital asset market in the United States. The assertion made by Ripple that the business was not aware that its XRP coin may be classed as a security until after the event is a crucial aspect of the company's case. After learning of the company's plans, the claimant claims that the SEC should have notified the company before bringing the matter to court. The government failed to give Ripple with what is known as fair notice as a result of its failure to do so. By the way, do you think these memos could change everything? Let us know in the comment section down below. The SEC may object to the token's present status if it is revealed that Ripple was aware of the likelihood that the SEC might object, and this powerful argument may be rendered meaningless. The following is an excerpt from an interview with Cointelegraph conducted by Peter Vogel, of counsel at Foley & Lardner, who is also a member of the firm's blockchain task force. U.S. District Judge Annalisa Torres ruled that by February 17, Ripple would have to make public sealed legal memos from 2012 from Ripple's lawyers advising Ripple before launching XRP. The SEC claims that Ripple was advised in 2012 that XRP would be deemed a security under federal law, so Ripple was well aware of the risk that the SEC would bring a lawsuit. Ripple claims that the 2012 legal memos related only to proprietary internal strategies. Assuming that the records indicate indisputably that there was no violation of federal law, Ripple's case will be significantly strengthened. Any proof that Ripple's leadership purposefully chose to disregard its attorneys' relevant concerns before releasing XRP, on the other hand, has the potential to dramatically undermine the company's fair notice stance. At the Yahoo Finance All Markets Summit in June 2018, William Hinman, the then director of the SEC Division of Corporation Finance, said something that market participants interpreted as a warning to market participants about what the commission considers to be a security and what it does not consider to be a security. Rather than reflecting the perspective of the agency in question, the regulator claims that Hinman's statements represented his own personal viewpoint. Unexpectedly, Judge Torres invalidated SEC Chairman Christopher Hinman's speech, which the agency is currently challenging on procedural grounds. It is possible that the verdict will be maintained, and that this will have a substantial influence on how executive agencies use the idea of deliberative privilege in the future. Comment, XRP Army, if you believe Ripple's overall success in the case. Generally speaking, evidence that indicates the process by which an executive body arrived at a particular decision or policy is protected from public disclosure under common law regimes, according to the concept of privilege from disclosure. Internal the SEC papers that show the SEC rationale on how to designate digital assets, for example, are protected from traditional discovery in civil actions and Freedom of Information Act requests, such as those coming from a Freedom of Information Act request, according to the concept. Although Hinman's statements were interpreted by the SEC as reflecting his personal point of view, deliberative privilege did not apply to the SEC internal files referring to this speech, and as a result, these records are available for public review. According to Amina Hassan, litigation partner at law firm Hughes Hubbard & Reed, the debate over the scope of the Commission's deliberative privilege, which is currently continuing, is even more intriguing than the substance of the 2012 memos. The following observation was made by Hassan: if the court's decision stands, it could have a far-reaching impact, opening similar types of the SEC and other agency documents to discovery. While any discovery disputes around agency notes will necessarily be fact-specific and resolved on a case-by-case basis, the decision does provide litigants a helpful hook to seek similar documents from the government. Do you agree that this could become really interesting? If yes, then make sure to like this video. This means that cryptocurrency companies who will be battling the SEC and other regulatory bodies in the future may be able to obtain information that was previously unavailable to them. Hassan went on to say that Judge Torres' decision is also likely to cause agencies to rethink how they treat their officials' public speeches, which typically contain standard disclaimers that they express the views of the official only, not the views of the agency. Hassan said, the fact that Ripple chose to go to court rather than seek a resolution right away does not rule out the possibility of a settlement being reached at some point throughout the course of the legal proceedings. According to the legal experts who spoke with Cointelegraph on the matter, an agreement looks to be very much on the table at the moment. The following observation was made by Vogel: since around 95% of all claims are settled before going to trial, it is unlikely that we will ever have a jury trial, but the interpretation of these 2012 legal documents may be a role in some settlement of the present the SEC complaint, says the attorney. It is impossible to determine if the matter is close to being resolved at this point because the discovery and pleading disagreements are still ongoing, Hassan stated. However, because the stakes are so high for both sides, we cannot rule out a negotiated solution. The SEC may ultimately decide to settle the case without going to trial, but the litigation has already demonstrated that a well-funded cryptocurrency firm may cause significant issues for the SEC if it engages in open warfare with the regulator. What do you think about these memos? What impact will they have? Let us know in the comment section. If you want to continue to know about XRP, we have got 2 videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.